have 8:03. We have all our panelists and quite a number of participants. And so I think we'll get started. Good morning, everyone. I'm Leslie Stein, Director of the Government Law Center at Albany Law School, and I would like to welcome you to the third program of the 2022 Warren M. Anderson series. The mission of the Government Law Center is to help state and local governments better serve their communities through nonpartisan legal research and analysis by bringing together a diverse and inclusive group of lawyers, students, scholars, and community partners. We prepare students for careers as skilled and leading attorneys in public service, advance Albany Law School's unique connection to government, and inform nationwide conversations on government and the law. This year marks the 30th anniversary of the Anderson series. And today we have a distinguished panel of speakers on the important and emerging topic of the new Green Amendment to the New York State Constitution, which guarantees the right to clean air and water and a healthful environment. Our moderator will be Professor Jonathan Rosenblum, visiting professor of law at Albany Law School. He will be leading a discussion among three prominent professors of environmental law, namely Professor Rebecca Bratspies of CUNY Law School, Professor John Dernbach, Professor and Director of the Environmental Law and Sustainability Center at Widener University, Commonwealth Law School, and Professor Nicholas Robinson of Pace University, Elizabeth Haub School of Law. I encourage you to read their bios in the CLE materials provided to you. They have all agreed to remain for a few minutes at the end of the program if additional time is needed for questions. Before we begin, I would like to thank our series sponsors, Whiteman, Osterman, and Hanna, family members in memory of Sharon P. O'Connor, Albany Law School class of 1979, as well as our program sponsor, the New York State Bar Association. Finally, a code word will be announced during the program, which will be necessary to obtain CLE credit. I will now turn the program over to Professor Rosenblum.
Thank you, Judge Stein. Thank you, Patrick, Woods, sponsors, Richard Rifkin, Lisa Rivaj, and the Government Law Center. It is fantastic to be here this morning. We have a wonderful panel in Nicholas, Rebecca, and John. So let's just dive right on in. And Nick, let's start at the top with how this might all play out. In other words, from an environmental law protection standpoint, what can we expect as a worst case and a best case scenario in terms of the implementation and interpretation of Section 19?
Well, that's a great question. I wish I had a crystal ball. The worst case for me is if this becomes I'm just seeing my mic is having a problem. Can you hear all right?
Yes, we lost you for half a second, but you're back now.
So it's quite possible that the courts, the judiciary, may choose to play this down. We've seen some other provisions like the Constitution of New York's Conservation Bill of Rights, which people have forgotten about largely. It's in Article 14. And it was left up to the legislature to implement that rather than giving it any teeth right away. I don't think that's going to happen to this provision because it's in the Bill of Rights. It's self-executing. It's a very clear, short provision that doesn't need further legislative enactment. So I think the courts will embrace it. And that opens the door to the other half of your question. What's the upside? I think this is going to make a material difference in New York in how the courts interpret other protections and also fill the gap that exists where we do not yet have protection for clean air, clean water, or aspects, clearly demonstrated aspects of health. So I think the courts are going to be able to fashion remedies to give this right some effective meaning. And that's my, how far that goes is really an open question, but I think that's its potential.
Thanks, Nick. That's fantastic in terms of some of the constitutional stuff. Rebecca, John, do you want to weigh in on this as well? I'd love to hear your thoughts on best case, worst case scenario here.
Yeah, because my focus is not quite as much on the courts as it is on the executive branch of government and the way that this constitutional amendment, and let's just remember, this isn't just law, this is constitutional law, part of the body rules and doctrine and practice that governs the operation of all political communities in the state. That means that this has to change everything in terms of how the executive branch of government at the state and local level interacts with its duties under a suite of laws. Environmental rights to clean air, clean water, and a healthy environment have to be part of every decision that every executive agency and every actor makes in this state now. That is the clear and unambiguous will of the people of New York in overwhelmingly voting to add this to our state constitution.
Thanks, Rebecca. John?
Well, one way to think about it is that and I'm obviously from out of state. I'm in Pennsylvania, but New York has been pretty active doing environmental things now for, well, my God, at least since 1970, and of course long before. And so there's a mature, well-developed and sophisticated body of law in New York State. And on a day-to-day basis, I think a lot of things are probably going to stay the same. And you've got a whole set of statutes, you've got regulations, you've got all manner of other things that the state has been implementing. And so the question is, at the margins, at least in my view, at the margins, what difference does it make? And I think Rebecca is spot on her first point. In Pennsylvania, at least, the Environmental Rights Amendment has had a pretty powerful effect on the way executive agencies behave. The other thing that helps you, I think, is that at this point, having adopted the amendment, there's enough experience in other states that you can point to so that courts at least have some guidance in terms of thinking about how other states have used and applied similar amendments. Hawaii, Montana, Pennsylvania, other states all have a decent body of experience that you can point to and say, well, look, we understand that there's no federal analog to this. We understand that you can't go to the US Bill of Rights and find 200+ years of experience implementing something like this. We understand that you can't go to federal courts and find any experience implementing this, but still, there's some things that you can learn at the state level. So those, I think, would be starting points for me.
Can I just add one more thing, Jonathan, before we move
Absolutely,
on?
please.
And that is that I think the place where we're going to see this be transformative is in the context of environmental justice, in the context of how environmental benefits and burdens are allocated across our state. Because this amendment gives everyone a right to breathe clean air, not just people who live in a nice, fancy neighborhood. And that, I think, is where it's going to be most transformative, is in reshaping the way we think about how benefits and burdens are allocated for environmental decision making. We've already seen that starting with the CLCPA, but this is the Constitution.
Thanks, Rebecca. Yeah, I'd like to follow up on that point about environmental justice. First, can I follow up with you, John, on you had mentioned the Pennsylvania state constitution, and we can learn things from other jurisdictions that also have state constitutional amendments. Can you give us maybe some specifics about where and what they've been doing and what we might be able to see from those examples?
Well, a starting point, Jonathan, on that, in terms of understanding Pennsylvania's experience and how New York might make sense out of it, is to recognize that the Pennsylvania amendment includes, as its first sentence, language that is similar, not quite identical, but similar to the language that is in the constitutional provision that you all just adopted. Pennsylvania also has 2 additional sentences in its Environmental Rights Amendment. Those 2 sentences create a category called public natural resources and oblige the state to conserve and maintain those resources for the benefit of present and future generations, and explicitly makes the people the beneficiary of that public trust. So the second and third sentences add to sort of the common law trust that existed in Pennsylvania long before the Pennsylvania Amendment was adopted in 1971, but it also has a constitutional public trust, which in many ways is broader, and of course, because it's constitutional law, is stronger. A lot of the litigation lately that's been in Pennsylvania involves the public trust part of the Environmental Rights Amendment. But still there are things that I think you can learn from, and I'll just make 2 quick points on that. One, to Rebecca's point about environmental justice, the Pennsylvania Environmental Rights Amendment was basically buried for about 40 years by the courts. The amendment was first adopted in May of 1971. There were a couple of cases that were brought in the early 1970s against projects that were not obviously bad, and that forced and that led the courts to think that if you took the amendment seriously, you would shut down development in Pennsylvania. And so for 40 odd years, there was a 3-part balancing test that the courts used as a substitute for the text of the Environmental Rights Amendment, and no one ever talked about environmental rights. It was all this 3-part balancing test, and mostly environmental claimants lost under that test. So what happened in 2013 in a plurality opinion from the Pennsylvania Supreme Court, Robinson Township, is the court said, well, we really ought to look at the text of the amendment and not take this 3-part balancing test so seriously. And if you look at the text, you find a couple of things. In future courts, later courts have turned all this plurality opinion into law. And starting point is, when you put it in the Bill of Rights, when you put it in your Declaration of Rights, it's self-executing, at least as against the government, period. And you don't have to worry about legislation. No one ever says, oh my God, you need legislation in order for people to have free speech. No one says that, because the Constitution protects the public's right to get to free speech, at least again, as against the government. So that was a first point. A second point is to Rebecca's thought, is that when the people have rights, then everybody has those rights, and they have them equally. It's not good enough that some people have those rights and some people don't. And the Supreme Court plurality in the Robinson Township case made that very, very clear, basically saying, and that's, I think, the foundational piece for those of us who talk about environmental justice in Pennsylvania from the Environmental Rights Amendment, is the plurality opinion there was very, very explicit about protecting everyone, and that everyone had a right under the Environmental Rights Amendment. And I could say a great deal more, but I'll stop there for now.
Thanks, John. Just a reminder to everyone in the audience, please put questions in the chat box, and we'll try to get them on a rolling basis where appropriate. But if not, again, we're going to try to get to them at the end as well. But we'll try to integrate them into the conversation as well. Rebecca and Nick, did you want to weigh in on that at all, about what we might be able to learn from other jurisdictions?
Well, I think that's important to understand that when the Assembly and the Senate debated this bill and studied it, and they did so, of course, in 2 sessions. It's a long amendment process in New York. They were quite aware of the decisions in Pennsylvania and the decisions in the other state courts. So I think it's fair to say that when interpreting our rather clean and short and crisp Bill of Rights provision comes before the courts, they're going to take into account what has already been interpreted in other states about an environmental right. And we start with that as a implied understanding. So I think we're going to build beyond what you have in the other state courts. So that's sort of the floor from which we now move forward in interpretation.
Yeah, I agree with Rick. I think that New York, the fact that New York has the CLCPA suggests that we are already significantly above that floor, and this constitutional amendment has to be interpreted in line with, in the spirit that of that law as well.
Rebecca, maybe we can go back to the environmental justice point here for a moment. First of all, for those of you who haven't had a chance to see Professor Rebecca or read Professor Rebecca Bratspies' piece in The Nature of Cities, highly recommend it. It came out, I believe, in February. I think that's, correct me if I'm wrong there, Rebecca. This changes everything. Definitely worth a read. It kind of summarizes some nice points, including some of the things we've talked about here so far. But Rebecca, on the environmental justice question, like whose job will it be to effectuate Section 19? Are there or should there be a private right of action here? How is environmental justice going to play out?
Well, this amendment both empowers and limits the government, right? And what it's going to do, at least what I hope it's going to do, is to change business as usual for how the government administers the law in this state. Much the same way that, again, keep talking about the CLCPA, right? Much the same way that the CLCPA requires that climate impacts be considered as part of many governmental decisions and provides a reason for rejecting certain applications if they're not consistent with the state's climate objectives. I think we're going to see the same thing for environmental justice here. And my hope is that in the relatively near future, we're going to get some guidance, some official guidance about how the CLCPA should be implemented across a suite of state laws. But I mean, to sort of be really specific for a minute, this amendment should transform how secret review is conducted. And most of my work is in air pollution, so I'm just going to talk about Title V for a minute. But every Title V permit renewal should require a rethinking of environmental justice impacts. And just as a reminder, environmental justice involves both fair treatment and meaningful involvement of communities in decisions in which environmental choices are made. And I think we can look to the way state courts and state agencies treat property rights for an analog of how this process might look, right? There has to be what gets called an average reciprocity of advantage in terms of burdening these environmental rights, just like there is for burdening property rights. So polluting activity doesn't mean polluting activities can't take place in the state. They can, and of course they will. But for them to be constitutional, they have to meet a higher standard than they had to in the past, because the standard is no longer just public convenience and necessity. It's now the much higher standard of, does this pass constitutional muster in terms of burdening a fundamental right? One place I think we could see this really quickly is in applications for cryptocurrency mining. But and I think we can look at the recent denials of peaker plant permits here in New York City as sort of a model for the kind of analysis that is going to happen. Not necessarily that there will always be a denial, but that kind of analysis is going to be the rigor with which applications to engage in polluting activities are going to be analyzed. And
Jonathan,
one more thing, I just wanted to add one more thing because I forgot to say this, is that right, we are, New York City in particular is a non-attainment zone for ozone, and we're about to be reclassified as a severe non-attainment zone. And that means, let's just sort of sit with what that means for a second. That means that the air that we are breathing here in New York City does not meet the standard of requisite to protect human health. And that's got to be an important part of the way we think about what is compatible with moving to, I forget the term, I'm blanking on the term from the Clean Air Act, for moving towards attainment and not contributing to degradation in the context of a right to breathe clean air.
I think Rebecca is absolutely right in that analysis. The Constitution charges the governor with the duty to take care to see that the laws are faithfully executed. We have not had a revision to our state implementation plan for the Clean Air Act in some time. And as the American Lung Association reports, our asthma rates, not just in New York City, but across the state, are unhealthy. They're far too high. And I can see the administrative law system for the Clean Air Act in New York requiring the Department of Environmental Conservation to revise the state implementation plan in several places in New York to make us move toward attainment of clean air, which under the Clean Air Act is allowing an adequate margin of safety. So people with asthma are protected, elderly and children are protected. We've defaulted on that duty. And now we have a right in the Constitution. What happened in Hoosick Falls was debated in the legislature, that continuous having to be subjected to polluted water or poisonous water for 2 years or more. Well, we've been subjected to poisonous air for a long time. And now I think we're going to see a substantial strengthening of our regime for cleaning up the air in New York and maintaining it in a healthy state.
And if I could just add one other thing to that is when we're talking about New York SIP, just one example of places that the state might be vulnerable to a challenge in court is that New York counted in its SIP reductions that were assumed to flow from the Port Authority banning pre-2007 trucks at the port facility in 2017. Well, in 2016, with virtually no public even announcement, the Port Authority changed that plan. But New York counted those reductions in the SIP, and they did not materialize because those trucks are still serving the port. I think that would be a really powerful vulnerability that New York has right now under the Article 19.
If I can add just a couple of things, thinking about sort of how it fits in with other constitutional provisions. The starting point, I think, might be looking at analogous provisions in the state's Declaration of Rights and saying, what can we learn about the jurisprudence, for example, under the First Amendment or under similar rights that are phrased in a somewhat similar way as the recently enacted amendment. And I'll give you an example from another state. Montana has a similar provision in its constitution as the one that New York State just adopted. And what Montana's been doing, beginning with a case called the Montana Environmental Information Center case in 1998, and most recently an opinion that's in district court in Montana, is they've applied a strict scrutiny test for the imposition of burdens on protected environmental rights, and requiring the state to show that there was a really good reason for doing what it had done, that it used the least restrictive means and so forth. A very, very similar test to the test that they employ, I think, for other constitutional rights, including the right to free speech. So I think that's something to look at. A second thing to look at that is a more sensitive point for a lot of Pennsylvania lawyers is what exactly is the burden of proof in showing that a constitutional right has been violated. And we haven't had a lot of really good experience with the first sentence of the Environmental Rights Amendment. We got that wrong a long time ago, back in the early 70s. And so a lot of the litigation in Pennsylvania has been under the public trust part of the Environmental Rights Amendment. But still, the way the burden of proof issue shows up is in several ways. Is how bad does it have to be? What's the role of the court in parsing technical issues that are normally left to the discretion of administrative agencies and that kind of thing? And part of an answer, I think, is provided by what Rebecca just said, for example, with the trucks, is if you have things that the state has done wrong that are easy to explain to a non-expert court, then I think it goes down a lot easier than if, as a lot of the people on the corporate side, Pennsylvania lawyers argue, well, you know, is the Pennsylvania Environmental Rights Amendment really one where the court gets to second guess parts per million standards and that sort of thing, and that issue does come up, and I don't think there's any way of stepping around that, and that's just something that I think the state is going to have to deal with. The one last thing I want to say, and this comes up particularly in Pennsylvania on the public trust part, but I don't think it's limited to that, is that when you get into conflicts with other environmental rights, say property rights, just to pick a fairly significant example, the route to go there, I think, is really, if you've got a direct conflict, and this doesn't happen very often, but if you've got a direct conflict between two claimed constitutional rights, then courts ordinarily engage in some kind of balancing process. And again, you'd have to look at the jurisprudence in your own state to see exactly how the courts deal with that. But that's probably those cases will probably be the model that your courts will start with.
That's really helpful, John. So there's a lot of things that the three of you just mentioned, including burden, conflicting constitutional rights, and also the potential for this amendment to apply to a variety of areas. You had mentioned property law. We heard about trucks. We heard about sort of our classic thinking about this in clean air, clean water. There's a question in the text in the chat box, which looks to kind of get the outer reaches of the amendment, in the sense of what context can we expect that this could potentially be applied to? Nicholas, did you please?
Yeah, well, I think we look at some of the other rights in the Bill of Rights to give us some guidance for that. In Article 1 of our Constitution, we have contextual interpretation of these classic rights. Freedom of religion, there's a large body of law on that. The right to petition government under Article 9, the equal protection provisions of 11. I think the due process clause is perhaps our best example, in that you now have to read due process together with the right to clean air, clean water, and a healthful environment. And the procedural steps to attain that right when it's been abridged or denied or it's being frustrated by some behavior is something courts can understand. There's basic unfairness there. And if the unfairness cannot be removed, then there has to be a remedy to gradually or progressively remove it. And we've seen in applying the due process clause in many different contexts, courts deal with that unfairness. It's not exactly balancing. It's really more a question of achieving the path by which due process and fairness is established. I think we're going to see not so much a conflict between the provisions of the Bill of Rights, but rather ways to learn from what the courts have already done in our Bill of Rights. Judge Judith Kaye wrote an article some years ago in the St. John's Law Review, arguing that our New York courts have always been more focused and I might say progressive in interpreting our Bill of Rights than has been the federal judiciary. And she argued that there was a dual process of understanding these rights. We are not bound by what has happened in the federal courts in interpreting these rights. But ultimately, it's in the context. Clean air, clean water, and the healthful environment has to be measured against the claim that's being brought for the alleged denial of those rights. And it will be hard to do that in many instances, because as in all environmental litigation, you need to hire consultants, you need to have experts that can marshal the evidence of what's happening to the environment, presented objectively to a tribunal. Or I should say also, I second what Rebecca said, the executive branch is going to have to look at that test also. And I was very active as the chair of my local planning board for a number of years. I think, and I was on my school board for a couple of terms, and I don't think these levels of government have yet quite understood that they too now have an obligation to achieve the attainment of clean air, clean water, and a healthful environment. All levels of government now have to begin to think, what is their mandate? And we do have ways of doing this. Companies for a long time have been using environmental management systems and environmental audits and hiring third-party environmental auditors to come up with methodologies to ensure that they stay within the requirements of environmental law. I think those tools are now going to be used by other agencies of government as well as the private sector.
I agree with Nick that due process interpretation and equal protection in New York will offer us guidance for what Article 19 means. Because like the right to property enshrined in Article 7, or the right to petition the government enshrined in Article 9, or the right of freedom of religion enshrined in Article 3, Article 19 now guarantees a fundamental right to clean water, clean air, and a healthful environment. And fundamental rights are rights that citizens cannot be deprived of without due process of law. Much like having Article 7 doesn't mean that the government can't regulate property, right? It's not that we can't engage in polluting industry in New York. Of course we can. But what Article 19 does, just like Article 7 does for property, is set parameters beyond which the government cannot go in approving activities that burden fundamental rights. And I mean, to my mind, I think we can see a clear example in even in some of the federal litigation on this, like the Penn Central case has a sentence that really encapsulates how I think, or how I hope, that this amendment will pay out. And in that case, the court reminded us that due process and equal protection, right, what that's around the right to property in that case, as opposed to environmental rights, it's designed to bar the government from forcing some people alone to bear burdens, which in fairness and justice should be borne by the public at large. And I think that is the balancing that courts are going to have to engage in when there are challenges to agency decision making. So do agency choices about permitting, about citing, about a whole host of activities uniquely burden racial or ethnic minorities, or uniquely burden low-income communities, and particularly where there's no reciprocity advantage, where those burdens are not offset by benefits flowing to those communities from those activities. And courts do this all the time. They'll just be doing it in this context as well. It's not like some mystical thing they have to invent out of whole cloth.
I'd like to ask you, the three of you, one more question about some litigation, and then there's a question in the chat box, but also several others about potential legislation and also administrative actions. And the question, last one on litigation, and of course others are out there, is in the chat box, and it has to do with what is the scope of remedies potentially available to private litigants against state action. We're looking at injunctive, damages, consequential. And so if anyone would like to take that one on first, please go ahead.
Well, let me just throw out one or two quick things on this. The kind of relief that we've talked, that typically has been asked for in Pennsylvania is injunctive or declaratory relief. And we really haven't seen damage actions or claims for damage actions at this point, at least not that I've seen. The other thing that I would say is that one of the really big questions in Pennsylvania, right from the very beginning, is can you use the first sentence of the Environmental Rights Amendment, which again is the one that is similar to yours, can you use that to sue private parties? And the Pennsylvania Supreme Court, actually, the Commonwealth Court, then the Supreme Court, more or less said yes to that in the early 70s in a case involving the Gettysburg, a tower, proposed observation tower right outside the Gettysburg Battlefield National Park. And that case is basically radioactive. No one wants to cite that case. No one wants to use that case. No one right now, not even the Supreme Court, when it summarizes what the first sentence of the Environmental Rights Amendment is about, wants to come anywhere close to saying that you can use the amendment against private parties. That, by the way, is what led to the conversation in Pennsylvania about whether the amendment ought to be self-executing or not. People said, holy smokes, if the amendment empowers the government to sue private parties, then you need legislation for that. So that's
We've always, in our interpreting of this, the discussions before the election and after, I've always observed, I don't think it creates a private right of action against private parties. This is a personal right held by each person in the state of New York. You don't have to be a citizen. Any person in the state of New York has a personal, guaranteed constitutional right to clean water, clean air, and a healthful environment. And it is the government that is on the hook for providing that right. Now, when you bring a suit against the government and there's a permit involved, it's quite likely that the permittee that has activity going on under a government permit that is alleged to be harmful will intervene in a case. You may even have to provide that for the relief that party be a necessary party to the suit, but that doesn't mean you're suing that party. What you're doing is you are vindicating a right in the Bill of Rights. And that it means the litigation here will be, I think, against government agencies at all levels or any levels. All levels of the government have to begin addressing how to comply with this or observe this right. But it's a personal right. And I've also had a number of discussions with people to say, well, does this allow class actions? Does this allow public interest litigation and so on? Well, only insofar as an individual can make a credible case to a court that their personal right has been infringed. It's not, in none of the other states have we seen floodgates of litigation open up. It's very hard to frame a personal right and then persuade a court that it needs to be vindicated. So it's going to be done carefully and I think, but effectively, I hope.
And I would recommend people Nicholas's 2017 piece in the Pace Law Review, where you lay out some of this stuff, some of the early conversations concerning the private right and concerning this particular amendment. It's a great piece. Again, it's in the Pace Law Review by Nicholas Robinson. Rebecca, did you want to weigh in on this point as well?
I think that Nick said it really well. I think that this is this both constrains and empowers government. And the government will be regulating the private sector, but that just doesn't give an individual a right to sue a polluter. That's not how constitutional rights work. They can only be infringed or guaranteed by government action.
just to sort of button up that last point, that's basically the argument that I've made in a lot of the scholarship that I've done on the Environmental Rights Amendment over the years. And actually the revitalization of the Environmental Rights Amendment in Pennsylvania has really been framed around the Environmental Rights Amendment, both parts actually, as constituting limits on what state government can do. The only other thing I would say, though, that to come back to a prior point, is that while a lot of folks in state government see the revitalization of the Pennsylvania Amendment in recent years as providing them a kind of North Star for navigating the policy calls that they make, the level of activity and understanding at the local government level has, to say the very least, lagged in this state in terms of what's this mean for us at X township or Y municipality, and that's something where a certain amount of work, I think, at least in Pennsylvania, remains to be done.
Can I just add one thing, and that is I would hate to see either the executive or legislative branches of New York's government waiting for lawsuits to figure out what this means, because the ball is solidly in the court of the executive right now to implement and take care that this constitutional provision be faithfully executed. And the legislature certainly could do a lot to strengthen how it will be factored throughout government in New York, right? There's a ton of positive law that could support and implement and flesh out this constitutional right. And we don't need to wait for somebody to have the right case to bring to court to litigate over what this means. That's
great, Rebecca. And so first, I do want to mention, Professor John Dernbach has been writing about these issues for over 20 years. He's got a piece in the late 1990s in Penn State Law Review on constitutional amendments, environmental law. And then another one just most recently, right, John? I think it was this year you had one published in ELR. So a lot of great things that all of our panelists have written here, and definitely worth checking out. But Rebecca, can we stay with that last point that you made about administrative agencies? And maybe can you talk about both what we might see in terms of new regulations and what criteria agencies would be using to implement those regulations, to promulgate those regulations, and then also on the enforcement side too, what we might see coming out of changes in enforcement?
Well, like I said, I would really like to see guidance along the lines of the guidance that DEC issued for the CLCPA. So, that in a systematic and thoughtful way rethinks what it means to implement law in the context of environmental rights. We don't have that yet, but it's only a couple of months, so it's not the kind of thing you just add water and produce. But there are a host of decisions, and I'm glad you mentioned enforcement, because enforcement decisions and enforcement policies are a place, again, where the individual right to clean air, clean water, and a healthful environment should really be shaping the way that enforcement priorities are set up. And quite frankly, maybe even like down to the level of changes to that check sheet that an inspector goes out with to assess whether or not a facility is complying with its broader duties, like not just the amount of a pollutant that it is emitting, but all the permits include sort of general duties in terms of not creating nuisance, in terms of odor, in terms of noise, in terms of areas where, what we call locally undesirable uses, right? Uses that are not friendly neighbors, that are mostly concentrated in environmental justice communities or the environmentally disadvantaged communities, right? This amendment, I think, gives those inspectors and the agencies sort of more ground to stand on to insist on stricter compliance with those kinds of sort of broad requirements and permits that tremendously impact communities in terms of the quality of air and the water and the healthfulness of their environment. Sort of lost myself in that sentence. Sorry about that.
No, I think it was great, Rebecca. I think that the Department of Environmental Conservation, for which I served for a time as general counsel, has a tremendous team of specialists who can begin to scrub each one of the provisions in the environmental conservation law that they are charged with implementing to determine what additional safeguards will be needed to implement our new environmental rights. Clearly, the Environmental Justice Directive and policy and guidance that DEC has put out will have to be upgraded along the lines that Rebecca has said. But it applies right across the board. The same thing needs to be examined in other agencies, because all agencies have this duty. It's not just a DEC responsibility. And all agencies contribute in some way to a healthful environment for people in the state of New York. And just to go back to my other point, there is a voluntary organization called the International Standards Organization, ISO, which has put out procedures, ISO 14,000, for showing how companies, commercial enterprises should comply with environmental laws and be able to verify and show that they're in compliance. And now we have ESG standards in which stockholders are urging companies to prove that they're green to the extent it's relevant to investments in those companies and so on. So companies have been doing this for a long time. I think some private sector companies are ahead of our state and local agencies in doing this. And the US EPA has issued guidance on environmental management systems, what you should do to bring yourself into compliance with the environmental laws. And because the environmental laws have not been as rigorously applied as perhaps the legislature anticipated they would be, we now have a chance to go back and rethink that. And indeed, we don't have a chance, we have an obligation. So I think the tools are there. I don't think we have to write a new book. What we have to do is study up on those tools. It's going to be a great few years for continuing legal education. I thank Albany Law School for this program, but it's going to be just the first of many. And I think all of these aspects that we're probing here for the first time will then be refined and applied and become a whole new dimension in the practice of environmental law in New York and perhaps all law in New York.
If I can, Jonathan, just two points to build on what Nick and Rebecca said. What in Pennsylvania, our experience is that one of the values that the amendment has, now that it's been, if you will, brought back to life by recent court decisions, is it serves a gap filling role where statutes and regulations don't really do the job. The Environmental Rights Amendment provides kind of a backstop role. In some ways, it's a little bit like the common law, except it operates on a constitutional level. And that has two consequences. One is what Rebecca and Nick talked about, and that is that it behooves state agencies, and this is beginning to happen in Pennsylvania, to look at the suite of regulations, guidance documents, and even statutes they have and say, you know what, where are the soft spots? Okay, where are the places where we're really not doing the job, and can we fix those? And some of that can be done with guidance, some of it can be done with regulations, and figuring out a way as an agency revises its regulations from time to time. That would be, I think, something that would be something that would be appropriate and worth considering. But the second part of this is on the private sector side, because I expect a lot of the folks that are on this call are in the private sector and have private sector clients. And the question is, well, what do you do? And the line that you hear judges talk about and a lot of private sector people talk about these days is that in Pennsylvania, at least, a lot of environmental claims, when the complaint comes in or the petition for review or what have you, there's often an Article 1, Section 27 claim. And what do you do with that? And it reminds me a little bit of when I worked in state government, as every private sector person who was unhappy with a government decision had at the end of their complaint or petition for review a takings claim. So now we're sort of dealing with the other part of that. And a lot of those don't get very far because they're not very serious. But one way to think about this, if you're putting together a project for a client or you've got a proposal for a client, is look to see where the soft spots in your proposal are. Look to see where your litigation vulnerabilities are and encourage your client to fix those. And that's a role actually a lot of private sector lawyers have begun to play in Pennsylvania. And it's I think a positive thing. It's not evading the law, it's complying with the law. And it's ensuring if you're getting a permit that the state doesn't issue a permit that's going to get you in endless litigation about whether you're protecting, for example, a particular community. And so I think that's something that's been going on a lot in Pennsylvania.
Great point, John. And I want to come back to that in just a second. First, very quickly, for those of you looking for CLE today, the CLE code word is green, G-R-E-E-N, green. One of the questions in the chat box, though, before we come back to that last point, John, that kind of takes us back into litigation, concerned more of a structural question around agencies. And the question was kind of focusing on whether or not you think there will need to be a new executive office that is kind of responsible for helping agencies move this along in terms of integrating it into agencies, into the work that they do through the rules and through enforcement actions. But I think there's also a larger question there concerning enabling authority and whether or not you think that agencies essentially have the authority they need right now to move forward with everything they need to do, or we'll need to see some legislative action first.
Well, I mean, I can't speak to New York, Rebecca and Nick can, but I'll just tell you give you a quick answer to that here. Because the issue comes up all the time. Okay, does the government have the ability to implement the amendment in the absence of legislation? And in my basic answer is it imposes, even the first sentence imposes limits on what the government can do, period. And you don't need legislation for that. But the issue of legislative authority comes up a bunch still. And so, for example, in the last, I think it was a week ago Saturday, in the Pennsylvania Bulletin, our regional greenhouse gas emission, regional greenhouse gas initiative regulation was published, and already there's litigation about it, and already one of the claims is that the state doesn't have the authority to adopt a regulation like that. We filed, a couple of us filed a brief in the Commonwealth Court yesterday, saying, well, look, one, the state has the authority under the Air Pollution Control Act to do this, and two, and this is the wrinkle that we employ, is that Article 1, Section 27 both supports and compels that decision. And there's a history that is not well known of Pennsylvania cases in which the amendment does not play a lead role. If you think about this from an Academy Award point of view, does the amendment play a lead role or a supporting role? Okay, and a lot of what we've been talking about is the amendment in a lead role. You violated, Article 19, right? You violated Article 1, Section 27. Here, though, the question is a little different. It's state exercises, can you use, is the amendment, I think, is properly used, and I would argue in New York as well, not just to in a leading role, but also to support agency exercise of its authority under existing statutes.
I agree 100% with John. Agencies have authority under existing statutes already to operate in the public interest. And what Article 19 does is clarify what is the public interest. What does that mean? But that's not to say that new legislation wouldn't be helpful to clarify, expand, and assist in implementation of Article 19.
This came up a little bit in the debates in the legislature and in the legislative history. There were some who said, well, if we pass this amendment, the legislature will be cut out of the action. The courts are going to take it over. And other people said, well, that's what a right is. We pass the baton over to another branch of government in this search for justice. So I think the state has all the authority it needs in the executive branch, and through the competences that have been given to local governments and other state authorities to act. And I think as long as they're acting under color of state law with the authority of the state, they have a duty to each individual in New York to ensure that this new environmental rights provision is implemented. How they do that is going to be a challenge that's uniquely different in every agency. But the basic standard and the authority to act, I think, is clear.
Thank you, Nick. So I wanted to give you all, we only have about 2 or 3 minutes left, and I know you've all graciously agreed to hang on to answer any questions that were left in the chat box. But before we close the official program at 9 a.m., I wanted to give you all a moment to give us maybe just some parting words about this is the most important thing we're gonna want to think about in the next year or 3 years for purposes of this amendment.
Well, I think we're going to have an interesting year of debate from the Climate Leadership and Community Protection Act implementation and the decisions that come out of that. And I think that's going to inspire a lot of discussion on how can we protect our health as a stepping stone toward averting climate impacts. So I think we're going to see immediately a debate about the Green Amendment come up in the context of climate change. And I think that will bring some interesting discussions into what we've been talking about for the past hour. How do we implement this right? It'll be a focused implementation debate.
I also think it will be part of a broader discussion of racial justice in New York, because we have staggering environmental inequalities that break down along racial lines, and the impacts for life prospects and health are pretty grim. And I think the COVID-19 pandemic has shown us just how disparate the environments that people live in are in New York, and how that can dramatically impact their health. So I am expecting that as we talk about moving forward in a more racially just manner, as we deal with the climate crisis at the same time, that this will be a touchstone that will help us navigate those complicated conversations and challenges.
The thing that I would say is that your Article 19 opens up a brand new landscape, and the early cases under this are going to be exceptionally important, at least for the next few decades. And so if you're involved in this litigation, if you're bringing one of these cases, pick cases with some care. The early experience in Pennsylvania in terms of rejection of the amendment or making the amendment feel like it was radioactive were claims that were brought on based on fairly marginal or questionable, at least by Pennsylvania standards. The environmental harm wasn't that great. The harm to other people didn't seem that great. And it seemed like that people were just kind of going overboard with litigation, and the early decisions by the courts created a legal environment that made it really, really hard to make much progress with the amendment. And so pay a lot of attention to the choice of cases, the way in which cases are brought, the way in which those cases are resolved, because those cases are going to have a very large impact on how the amendment is understood over the next, your amendment is understood certainly over the next several decades.
Thank you, John. That's great advice. Thank you, Rebecca and Nicholas. As a reminder, everyone, the CLE code word is green. We're going to turn to a couple questions in the chat box that we didn't get a chance to get to now. And anyone who wants to weigh in, Rebecca, John, or Nicholas, please feel free to do so. The first question is, could actions against the government enhance tort standards?
Well, I think the Green Amendment is going to already require us to reinterpret other doctrines. It's going to have, I think, an influence on standing. If you have a constitutional right, you don't have as high a barrier in terms of entry into the courtroom. I think it will have a influence on nuisance law and other torts that may be brought. But it's in that role that John Dernbach pointed out. It's not maybe the prime claim, it's the supporting claim. But the supporting actors are influential. So I think it can have an impact.
Tort law is really not my area, but I expect that as definitions get established as to what constitutes a healthful environment or clean air or clean water under this constitutional provision, that people will use them to argue by analogy in other contexts, and particularly in the tort context. But that'll be a spillover effect, not a direct effect.
Just the quick thing I would add is pay a lot of attention to the relationship between the environmental rights in Article 19 in public nuisance.
Great observation too. Fantastic. So first, it's green as in GREEN is the key word. So we have two other questions here. The first is for agencies that have had limits specified in statutes about what to consider or what actions they can take, would this constitutional right override those limits? Would this open municipalities and agencies to a wave of ultra vires claims?
Can I make a quick just reference to Montana? The Montana Environmental Information Center case that I referred to earlier was a case in which the state legislature excluded from review arsenic discharges from certain kinds of exploratory activities for mining activities. And the there was a direct challenge to the constitutionality of that legislation under the Montana Environmental Rights Amendment. And the Montana Supreme Court says, look, you've got to, this, we remanded it back to the district court and said, this could be unconstitutional. You've got to look and see whether, subjected to a strict scrutiny test, least restrictive means, and all that sort of thing. And so the answer is, and this is actually part of Pennsylvania's experience. If you have legislation that seems to be cutting back or is actually cutting back or going backwards on environmental protection or creating loopholes or creating exceptions, I think that kind of legislation is really vulnerable.
I think where there are specific limits, the test is not so much at the administrative law stage, but there will be a challenge to the statutory framework itself as creating a violative governmental action. And of course, in that case, if it's a regulation, the agency issuing the regulation will then have to deal with revising the regulation. If it's something the legislature has adopted in a piece of legislation, which is rare, that will be a very interesting question, because now, of course, legislative acts that are discriminatory have been held unconstitutional and therefore cannot be implemented, but it then leaves a question of what do you do next? But these are the kinds of issues that will be very interesting to work through in the next few years.
Rebecca, if not, I actually have a question for you, Rebecca.
Okay. Yeah, no, I think that John and Nick did a good job of laying that out. So go for it.
Okay, yeah, so you had mentioned earlier, and you partially actually answered this question, but maybe we can flesh it out a little bit more. You had mentioned SECRA, and the question in the chat box is, how do you see the Green Amendment affecting SECRA? And as I said, you touched upon it a little bit, but maybe there's a bit more that you wanted to flesh out with that.
Well, in its guidance, DEC sort of gives a nod to the notion that SECRA could have substantive aspects, but it clearly has to now, because there's a substantive constitutional right to clean air, clean water, and a healthy environment. And that means that SECRA needs to be rethought in terms of, again, it doesn't mean that people can't engage in polluting activities, because of course they can, but it's a process that needs to be rethought about what exactly does public convenience and necessity mean? How are benefits and burdens being balanced? Who is being burdened and who is being benefited? I think it's going to require rethinking what sort of is business as usual and standard practice under SECRA.
I agree. I think the State Environmental Quality Review Act procedurally is fairly rigorous and carefully structured, and all across the state at all levels of government, people understand it. What has happened is we've been using a great many environmental assessments rather than more thorough environmental inquiries. And in some cases, even saying we don't need to do it, we can mitigate all impacts and therefore let's move on. I think the new amendment requires us to go back and rethink that pattern because unless you can show that the clean air, clean water, and the healthful environment have been addressed in the course of the impact assessment, of course, you can't say whether you're protecting the public or not, the persons. So I think individuals adversely affected will be able to require the seeker review to go back to a more careful review. Now, I agree with Rebecca that California and New York are states that kept the substantive requirement in their impact assessment. The Supreme Court removed that from the interpretation of the National Environmental Policy Act, but it's still there in the state laws of the more demanding states. And so I think that substantive duty of mitigation and seeking the least adverse harmful effect will be interpreted differently now, because the least harmful effect has to, at a minimum, meet the provisions of the Constitution and the Bill of Rights for the environmental rights.
And cumulative impacts and aggregate impacts are going to be really important in that kind of analysis.
Just two quick observations. One is that there's a canon of statutory construction in Pennsylvania that you interpret statutes in a way that is consistent with constitutional provisions. And so where there's ambiguity in the environmental review law in New York, that ambiguity was going to need to be resolved in sort of in favor of an interpretation that implements Article 19. Second point, though, is that there's a case again in Montana where there was an exemption to the Montana Environmental Policy Act, and the claim is that the exemption was unconstitutional under the Environmental Rights Amendment to their state's constitution. And that case is before a district court in Montana right now. And so the other possibility exists that the environmental review law in New York may not be fully compliant with Article 19. I don't know that law. I'm just raising that possibility, and that's something that I think that you would need to look at and if necessary change.
Thank you, John and Rebecca and Nicholas. Fantastic and extremely informative panel this morning. It looks like we have a lot more to discuss on the mitigation front, the legislation front, the regulation front. And so it's a really exciting time to be talking about these issues. So thank you. And with that, I'll kick it back over to Judge Stein.
And thank you, Jonathan, and to all of our amazing panelists. And I couldn't agree more. It has been a very exciting and thought-provoking program. And we thank you all for your time and hope to see you again.